Hello and welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss important weekly legal updates from 21st November to 26th November 2022. In first important news, the Supreme Court has held that a contract is concluded only when parties are ad idem on all essential terms. The court in the case of Karnataka Power Transmission Corporation Limited versus JSW Energy Limited has held that if the proposals containing the essential terms have been accepted and the acceptance is communicated, and if other conditions of Section 2 of Indian Contract Act are complied with, then it would lead to the creation of a concluded contract. The parties can be said to have entered into a contract only when they are ad idem on all the essential terms of the contract. In second important news, the Supreme Court has observed that judgments of the Supreme Court are to be dealt with due respect by the High Courts, even though High Courts are not subordinate to the Supreme Court. In the case of Ramchand Bharti versus State of Telangana, the court has observed that the High Court of Telangana has not made observations in line with the findings of the landmark case of Arnesh Kumar. Therefore, the court noted that though it is always said that the High Court is not a court subordinate to the Supreme Court, but when the High Court deals with judgments of this court, which are binding on everyone under Article 141 of the Constitution, it is expected that the judgments have to be dealt with due respect. In third important news, the Supreme Court has held that court, while considering applications seeking appointment of arbitrator, cannot go into question of novation of contract. In the case of Meenakshi Solar Power Private Limited versus Abhyuday Green Economic Zones Private Limited, the court has held that while considering an application seeking appointment of arbitrator, the court cannot go into question of novation of contract and merits of any claim involved in the arbitration. Lastly, the Supreme Court has held that presumption under Section 139 of the Negotiable Instrument Act includes a presumption that there exists a legally enforceable debt or liability. In the case of J&P Jose versus Santosh, the Supreme Court has held that presumption under Section 139 of the Negotiable Instruments Act includes a presumption that there exists a legally enforceable debt or liability. However, the presumption under Section 139 is rebuttable, and it is open to the accused to raise a defense wherein the existence of a legally enforceable debt or liability can be contested. This brings us to the end of our weekly legal update. If you like this video, please like and share and subscribe to our YouTube channel.